Welcome to the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's News and Talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office at any time at 1-800-DeWitt-LAW. That's 1-800-DeWitt-LAW. Or interact with the show by sending us an email to askdewittlaw.com. That's ASK at DeWittLaw.com. Every Sunday morning at 10 a.m., you'll learn how Florida legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo will answer your questions to discuss the latest legal issues affecting the citizens of Florida. I'm Casey Wright, alongside your host of the show, Mo DeWitt. Mo, good morning.
Good morning, Casey. How are you doing?
I'm good. How are you? So we're going to start off the show today talking about a new Senate bill, Senate Bill 1416, titled the Dissolution of Marriage. But as Mo mentioned to me earlier today, it's more of a reformed alimony. Why don't you explain?
Yeah, so I mean, if you've listened to this show before, I think the topic we've probably discussed the most over the last decade is alimony reform in the state of Florida. And we've discussed it the most because it's been in the legislature numerous times. I think this is the fourth time they've put it through. They put it through last year, and the governor vetoed it after it was passed. Just yesterday, we had another alimony reform bill that was passed in the House and the Senate, and now is going to the governor's desk to see if he's going to veto it again or not. And so before we kind of discuss that analysis, we'll kind of talk about what's in the alimony reform bill. And the biggest thing, and this has been the biggest push over the last decade really, is that it ends permanent alimony. So if you've been through a divorce, or if you know someone who's been through a divorce, and they were married for over 17 years under the old law, they would the spouse or the person receiving alimony would be entitled to permanent alimony. There was basically a presumption in favor of permanent alimony if you were married over 17 years. This bill eliminates that, so there's no longer permanent alimony in the state of Florida. And if you're a listener out there and you're paying alimony or you're receiving alimony, the question you probably have is this going to impact me? And so the bill that was proposed last year did have a retroactive component to it, meaning that it retroactively applied to all previous divorces. And the governor vetoed that because he found that to be unconstitutional. We actually talked about that last week because it infringed on the contracts clause. Basically, the government cannot pass a law that goes back and retroactively infringes on contracts that private individuals have entered into. And in most cases, a marital settlement agreement is considered a contract. So he vetoed it for that reason, because he found it to be unconstitutional. This new bill that was just passed this week does not have the retroactive aspect to it. So you can, so it will not impact you retroactively, essentially. So if you're currently paying alimony in the state of Florida, you're currently receiving alimony in the state of Florida, this bill will not impact you. If you are currently going through a divorce, it will also not impact you. It only impacts divorces that are filed or pending on July 1st of 2023. So if you're currently going through a divorce, this bill will not change the way that the court considers alimony. However, if you file a divorce in a couple months here, then you will be under this new law. So that's a big difference with that one than any prior version of this bill that we've seen. It's always previously had some sort of retroactive aspect to it, or it's had a child custody, child time sharing aspect to it. And if you've heard me on the show before, I've always said those have been the two problematic provisions in this bill. When it got passed last year, I was surprised that it had both of those provisions in it. Ultimately, the governor ended up vetoing it. Finally, this year, this bill does not have those aspects in it. So let's kind of dig into what else the bill does besides eliminate permanent alimony. But that is the big takeaway, is it's going to eliminate permanent alimony right off the bat. So we still have all the other types of alimony. We have temporary alimony, we have the bridge of the gap alimony, we have rehabilitative alimony, we have durational alimony. We had all those previously as well under the current law, but now we're just dropping off permanent alimony. So, temporary alimony is basically just alimony during a case to kind of get somebody through while the case is pending. Then you have bridge of the gap alimony, which is exactly what it sounds like. You're kind of bridging the gap from, being married to single life to kind of get you back on your feet. Rehabilitative alimony is somewhat similar. Typically, you have a rehabilitative plan that goes along with that. That may be going back to school to get a new job or something along those lines. And then I think under this new law, most alimony is going to fall under what we call durational alimony, which durational alimony is simply alimony just for a period of time. And the new law does kind of specify how you calculate that time. Under the current law, it's discretionary. So I usually tell clients that it's usually about half the length of the marriage, but under the statute, it can be up to the full length of the marriage. So this one, under the new law, it actually provides a percentage basis. So it may not exceed 50% of the length of a short-term marriage, 60% of the length of a moderate-term marriage, and 75% of the length of a long-term marriage. So those are still caps. It can still be less, but those are caps that occur on it. So we're not going to have permanent alimony anymore. So if you've heard us talk about permanent alimony before, one of the big aspects or big problems with permanent alimony is, you have a right to stop paying. You have a right to retire, essentially, right? So a lot of times what would happen is you'd get hit with permanent alimony. You pay that for 10 or 20 years or whatever it would be. And then at a reasonable retirement age for your profession, maybe that's 62, maybe that's 65. If you're an NBA player, that's probably much younger. Much younger. You go back and you have to file a whole new action. It's still within the divorce case, but it's essentially a whole new action to modify the alimony. And so that can be very expensive. And that you're basically going through a new divorce process to reduce or eliminate your alimony. And so that's kind of been the problem with permanent alimony or that's been the argument as what the problem with permanent alimony is that you have to go back to court again. I've had cases before where the two parties show up in court and they don't recognize each other because it's been so long. I mean,
Wow.
they just, they've been divorced 20, 25 years. And literally, we walked into a courtroom one time and my client goes, "Who's that?" I go, "That's your wife."
Oh my
And
goodness.
he literally had no idea. It had been that long. They'd been paying alimony that long. But they had no interaction. So this kind of helps eliminate, or the idea I think behind it is it's going to help eliminate some of those modification actions going forward, so that you don't have to come back a second time to modify the alimony. One interesting thing about this statute, though, this law that was passed, is it now says that courts will be permitted to consider adultery of either spouse and its resulting economic impact in determining the amount of alimony to award. So that's kind of a very odd thing for them to put in this law, in my opinion. Under the old statute, it actually did say something similar to that. But the case law in the state of Florida, at least, has all basically found that adultery is irrelevant. And there's, while it's a very personal issue, from a financial standpoint, from the court's perspective, I certainly understand why they have that in there because, as we've talked about before, to the court, a divorce is very much, with the exception of children, a financial transaction.
Right.
So when you add a provision like this in there, it really opens the door for mudslinging back and forth. I've had cases before where people have spent, a lot of time trying to prove adultery on the other side, and I go, well, it doesn't matter. The only time it matters is if you what we call dissipated marital assets. And typically that's you have a paramour, you have an affair, you're buying them jewelry, taking them on trips, things like that. You can pull that money back into the marital estate and then split it equally because that money should have been part of the marital estate. Basically, you squandered it. So I don't know if that's the intent of this provision or if it's something beyond that. The way it's written, it seems like it's beyond that, and that they can almost punish somebody for having an affair during the marriage,
Right.
one way or another. While that may, if you've ever been cheated on, you probably like that idea.
Yeah.
From the perspective of the court's efficiency and, making divorces efficient and fair and getting people in and out of the court system, and also not having the court basically dive into your entire marriage and analyze whether you've ever had an affair or not. I think it's very inefficient from that standpoint. It almost brings back if you remember the movie Liar Liar, where they were trying to prove that the wife was cheating, and they had those, it's almost that kind of, it's reminiscent of that, because right now the court would not allow any of that testimony or evidence in typically because it would all be irrelevant. Well, under this new law, assuming that it doesn't get vetoed, that may all come in essentially. And so it'd be interesting to see what does it mean when they say resulting economic impact. I would read that as it's really the same as the current standard. However, one could argue that it would have, psychological effects, things like that may be considered as part of the finances of the case and could ultimately change what the outcome would be. So it'll be interesting to see if this actually gets passed or not. It has been passed, whether it gets vetoed or not. My prediction would be that it actually will not get vetoed. The governor will sign off on it. I say that because, again, the two controversial aspects of this bill previously have been the retroactive aspect, meaning that it eliminated permanent alimony retroactively for all cases where someone was paying or receiving alimony. This one does not do that. And previously, there was a presumption of equal time sharing or 50-50 child custody. And so this one does not do that as well. So those were both kind of the controversial aspects of the bill. The bill that got passed last year had a lot of problems, frankly. It left more questions than answers. This year's bill does seem to be better written. And since it doesn't have that retroactive aspect, which, as the governor previously said, he believed it made it unconstitutional, this one does not have that. So I would suspect he probably will sign this into law. And then this will affect anyone who's getting divorced after July 1st of this year. Again, it doesn't affect you if you're currently going through a divorce or if you've been through a divorce previously. This only goes for initial petitions of dissolution of marriage that are filed or pending on July 1st of 2023.
Yeah, and SB 1416 marks the third time Sarasota Republican Senator Joe Gruters brought this form of alimony to the Senate floor. And from his words, he's saying it's providing parameters on the type, length, and amount of alimony, which Mo, you've explained already, to encourage a settlement negotiation, which leads to a less protracted and costly litigation. So again, it seems like it is trying to save people money in the long run. And like you just mentioned, if somebody's going into a courtroom and not remembering their spouse or their ex-spouse, rather, that should be notified in something like this where they're paying towards a contribution where it's been so long ago. So the 2023 edition of the reform package eliminates the permanent alimony and replaces it with durational alimony. What in this, Mo, makes you believe that the governor should sign off on this? What part about it?
Well, like I said, first of all, there's been a big push for alimony reform in the state of Florida. I know not everybody agrees with that. Obviously, it depends what side of alimony you're on. But there's been a big push for it historically. The holdup has been that the people who are pushing for alimony reform wanted it to be retroactive to affect all divorces that have previously been filed. And that's obviously problematic from a constitutional perspective, as we talked about with the contracts clause. So given that this one does not have that issue, I think it's the first time it has a real possibility of going into law. Now, they did add a provision into the law where it does modify the ability to modify alimony. It changes the ability to modify alimony, essentially, and outlines some better parameters for reducing or eliminating alimony. So while I said if you've gone through a divorce and you're currently paying alimony, this doesn't affect you, the actual bill of eliminating permanent alimony does not affect you, but it may affect you on the modification aspect. Whereas before, when you went to modify alimony, you had to show a substantial change in circumstances. This modifies that a little bit, especially if you're reaching retirement age, to where it may be a little bit easier to actually get your modification done, and hopefully it won't be as expensive.
We shall see. The legislative session is coming up to a close in the next couple of weeks. We'll see if Governor DeSantis signs off on this bill. You're listening to the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's News and Talk. Mo and myself will be right back.
So I get this call all the time. What should I do immediately after a car accident? Now, number one, of course, you want to get over into a safe place, somewhere off the road so that you're not in danger of being hit by a passing car, of course. Number two, you want to call 911 and you want to get an accident report if you can. Of course, if you're injured, you want to seek medical treatment right away. Even if you're feeling, some pain, some soreness, a lot of times people think, oh, I'm tough, I don't need to go see a doctor. You want to get checked out by a doctor to make sure there's nothing serious going on there. I've seen horrific cases where it was just some pain, turned out to be internal bleeding, and ultimately that ended up to be a very serious injury. And third and finally, if you are injured in an accident, call an attorney right away so they can start working on the case. You want to make sure that they preserve all of that evidence as soon as possible.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's News and Talk. I'm Casey Riley here with host Mo DeWitt of the DeWitt Law Firm. You want to get in touch with their office, you can call anytime at 1-800-DeWitt-LAW or interact with our show by sending an email to ask@dewittlaw.com. That is ask@dewittlaw.com. See, Mo, I keep spelling all morning because we have the WDBO payroll payout going on, and that's very important that I spell those words all morning long. But we're going to go to a question. We're going to go to those questions. And again, you can email us those questions at ask@dewittlaw.com, and we will answer those questions for you. The question we have, Mo, is this. I am currently separated from my husband and in the process of getting a divorce. When we separated, it was agreed that he would take over the payments on the car that he is currently driving. However, the car is only in their name. Just received the information that he has not been making the payments as promised. And not only does she owe the amount, but her credit score has been affected. She's asking about it. She asked him about it. She says he will not make the payments. So the question to you, Mo, is can she take the car away from him since he has been making the payments as he promised?
So, first lesson here is if you're going to have an agreement, it needs to be in writing.
Right.
So I don't know what stage these people are at in their divorce at this point in time. If they haven't filed for divorce, I always say it's like the Wild Wild West. You kind of do whatever you want. Now, once you get to court, the judge may not like what you have done, but there's no one telling you you can or cannot do X, Y, or Z. And if it was just a verbal agreement that this was going to occur, there's nothing that you can really enforce. So that's why if you're going to reach even a partial agreement, an agreement over whether it's a car or a house or, temporary time sharing or custody, anything that you're going to do as part of a divorce case, you should really make sure it's in writing and done properly. I've seen people come up with crazy agreements before, and they're just not enforceable. So that's why at least talk to an attorney, get some legal advice if you're going to reach some sort of an agreement. But here, he was supposed to pay for the vehicle. He's not doing that. She wants to take the car back. Well, if there's no divorce case filed, like I said, you can kind of do whatever you want. The car is in your name. It's your car. It's still a marital asset. It's, as much your car as it is his car, because anything that's purchased during the marriage is split 50-50 amongst the parties. So from that perspective, you can kind of do what you want. Now, if a divorce is filed, it's a different story because most counties in the state of Florida, or at least in Central Florida, have what we call an administrative order. So an administrative order essentially says what you can and cannot do during a divorce proceeding. And the purpose of that is essentially to keep everyone on their good behavior. They don't want one party trying to starve the other party out or take tactics that would give them an advantage during the divorce. A common example is you can't, let's say one party's the breadwinner. They historically have paid for all the expenses. The other party stays at home and, they've been supported, right? So the second you file for divorce, you can't just cut the other party off. Why? Because the courts don't want that person to essentially be starved out and then forced into signing some divorce agreement that's not in their best interest or that's not fair, essentially.
Right. Because the car is in her name, too, has make me curious. In a situation, let's say they haven't filed for divorce. Could she technically label that car as a stolen vehicle if he's not returning the car and he's making no payments? Because there's a gray area there that, with your background and my background, I could see that happening. And that's most of our stolen car calls ended up being family members.
Yeah. And so, when I think as from the criminal perspective, it would probably depend what officer showed up. I think, just like you said, they probably get this to kind of know, hey, this is really a civil matter. It may be depending on how it was framed. But if the parties are married, I think it's going to be hard to make an argument that the vehicle is actually stolen.
Right. Because
it would be marital property. In the state of Florida, as we've talked about before, it doesn't matter whose name the property is titled in. It's still a marital asset. That's, an asset of the marriage. So, even though they may want to claim it's stolen, ultimately, even if the police officer arrested the person, I don't think the charges would hold up. I think ultimately that would be dropped. That would be, not an expert here, and I'm not the state attorney or the prosecutor in this state, but that would kind of be my guess.
Makes
on
sense,
that.
Yeah.
But you're right. A lot of times people do want to report those things stolen because they're thinking that's the easiest way to get them back. Ultimately, in this case, I don't think that's really going to work, at least in my opinion.
Yeah, and especially you have a car get reported stolen, you do a felony stop on a poor guy just trying to go to work. It's not the most fun. You're listening to the Mo DeWitt Law Show here on WDBO 107.3 FM and AM 580. More content coming up next right after news, weather, and traffic. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's news and talk. Every Sunday morning at 10 a.m., we're going to teach you Florida's legal issues and how they affect you. With your host, Mo DeWitt, and myself, Casey Wright. Mo will be answering your questions to discuss the latest legal issues affecting the citizens of Central Florida. And Mo, before the break, we were talking about a issue between a husband and wife going through a divorce with not a stolen vehicle, we'll get to that part, with a vehicle in question that is in the wife's name, but the husband's driving it. He verbally agreed to pay for it, but kind of need to know more information about whether or not where they are in the divorce process. And then you asked me during the break, I was a former law enforcement officer, for those who don't know, the situations that happened to me. And I mentioned a story to you that it did happen to me several times, but one that I can remember was a girlfriend called in a stolen vehicle on her car, on her boyfriend, or fiance, I guess you can say. And we ended up doing a felony stop. For those who don't know what that is, that's 4 cops all drawn behind you with guns asking him to get out. They move to the left, move back, move awkward. They're screaming, what am I doing wrong? And then we found out the car's in his name and he makes the payments.
Oh, really?
So it's one of those situations where they weren't married, they weren't in a divorce process, but he had taken the car for the day. He was not giving it back to her because he had to go to work, and she got upset, frustrated. So, the main story about this all Mo, is we're seeing a lot of people call law enforcement, tying them up for civil issues when they think it's criminal. So, do you have a PSA out there for any of these people that continue to do this, or do you have any advice for people before they call 911? To maybe call you first?
Well, when we're dealing with divorces or people going through family law matters, obviously we deal with this a lot. And a lot of times people want to call the police for every time there is a child exchange or something goes wrong in their case, or, whatever it may be. And you have to be kind of careful with that because, anytime you do that, that's going to be used as part of your case, on one side or the other. And so it could be used if you're always constantly calling the police on the other side. They can show that to the judge to show, hey, you're not being reasonable here. You're not co-parenting. You're not being cooperative. And in some cases, maybe you're even downright lying to the police, which can obviously be a crime. I know it's not prosecuted very often, but making false 911 calls can be a crime. And so in a situation like the one you discussed, while they weren't married, they were engaged, there's certainly a question of, okay, at some point, she consented for him to use the vehicle, right? And then she claims, well, I withdrew that consent later on. But then how did you communicate that withdrawal of consent? Did you give them enough time to return the vehicle? If they were in the middle of the workday and you said, I need the car back here in 5 minutes, that's probably not reasonable. If the car's been missing for a month or so, assuming that it was in the other party's name, obviously,
Yeah.
Then that might be a different story. But we see this all the time where, especially with cases involving kids, and the parties just don't get along. Every time there's an exchange, every time something doesn't go wrong, every time somebody's late to pick up or drop off the child, they're calling the police. And ultimately, when those cases finally end up in court, in my experience at least, the judges really don't like to see that. And so, because first of all, it's horrible for your kids to have the police around all the time. Especially the police showing up. They're asking mom questions. They're asking dad questions. What's going on? It's got to be very traumatic for a young child to constantly kind of be in the middle of that to begin with.
And if you're doing that, just to kind of reiterate something that I used to go through, when you have the child exchanges and or possibly property exchanges when you're going through a divorce, there's a thing called escorts. When police law enforcement officers, they do escorts.
Right.
You're in court. Does that come up on court that they asked a police officer to come and escort them for a child exchange and or a property exchange?
So in contentious cases, that is normal. It does come up sometimes, but I think it's more accepted by the judges than calling 911 all the time. Because the escorts are typically a little more planned. And so, to save resources a lot of times, if it is a contentious case where an escort may be involved, sometimes we'll suggest doing the exchanges at a police station or a fire station. Sometimes people don't like doing it at police stations because, again, the same visuals to a child of, you have to go to the police station to have mommy and daddy interact type deal.
Right, that's not good.
But, a police station, a fire station, sometimes even just a gas station where there's lots of cameras. So if something happens, it's certainly documented and there's lots of people around. So sometimes those are ways to kind of avoid having the police escort. Now, when you're dealing with things like domestic violence injunctions, typically if a domestic violence injunction is granted against one party, usually they're allowed to go back and get some of their personal belongings, and usually they have an escort for something like that, and that's very normal and very common. But certainly, you don't want to live your life where you have to have the police involved all the time. I get things get contentious, and there can be safety concerns and things like that, but constantly calling the police on the 911 line certainly is not a good
right.
thing.
And there are regulars. It happens. It's
right.
very normal.
There's absolutely regular. I mean, I've had cases before where the police show up and, yep, we know these people. We've been out here, 20 times. And so, that's not a good thing for anyone, really. But in certain circumstances, especially, like you said, with property exchanges, sometimes things can get contentious, and so those are situations where a police escort may be appropriate just to make sure that the peace is kept. And so if you need that, you can properly arrange it. But again, you don't call 911 to do that.
Right. So an escort would be a positive way of people trying to, play, I guess, referee.
Yeah, I mean, I would say it's still somewhat of a last resort. You don't want to be doing that for every little thing. You don't want to have an escort twice a week for your child exchanges, and anytime you have to communicate with the other parent. I mean, that's not typically good, but I get it. It can be very hard to co-parent, especially if one parent's being very difficult. And we've had some of the most difficult cases before that involve violence and arrests and all sorts of crazy stuff. And sometimes in those cases police involvement is necessary, but as a former law enforcement officer, I'm sure what you don't like to see is, hey, someone's calling 911 because, mom or dad didn't include the kids' gym shorts, that kind of stuff. And that sounds ridiculous, but it does happen. Being a 911 operator, I'm sure they would get all sorts of crazy calls like that.
I've had some crazy ones in situations like that. I guess the craziest comes to mind was he went to Burger King with his girlfriend, and she refused to give him his food after their fight. So he called 911 and asked us to get the food back from her. So that was an interesting case scenario. But it happens. Like you said, people call 911 for everything. If you're a 911 dispatcher, the stories when you come home must be insane.
Yeah, and I mean, probably draining too.
It's definitely a long day, 12 hours
of,
I guess you could say, babysitting the county. And hopefully it's mainly supposed to be called 911 for emergency purposes. Well, all right, let's go to questions now. Let's stay on the car trend, as we have a question that says, what can I do if my Gap insurance does not want to cover my balance after a serious car accident?
Well, really, there's not much that you can do if you don't have Gap insurance. So Gap insurance is literally there to cover the gap. So what it does is it covers the gap between what your vehicle is worth if it was totaled and what you owe on the loan, what your finance total is. So it only really applies if you're financing the vehicle, which most people are either financing or leasing. But if you're financing it, it applies there. So there can be situations where your vehicle's totaled. Let's say you get 10 grand for the vehicle, but you owe 15 grand. Well, now you have to come out of pocket for the extra 5 grand to pay off the bank because you owe them the $5,000 and the car has been destroyed. So Gap insurance helps protect you for that. So it covers that difference between what's the vehicle's worth, what they pay out, what the insurance company pays you out, what it's being worth, and what you owe on it.
And if it's finance, it's usually pretty cheap too. It's not like an extra.
It's not a crazy insurance. It's just something that people have to be aware of. When they're buying a vehicle, to make sure they have it. Because if you don't have it, there's nothing you can do.
You're done, yeah.
Obviously, if you do have it and they refuse to pay, depending on the reason for the denial, you may have a cause of action against them. They're usually pretty straightforward claims. They're usually not disputed claims. But if you don't have the Gap insurance, or you thought you did and you just end up not having it,
out of luck,
then you're out of luck. Yep.
Yeah, and it's one of those things where if you are, I think when you lease, it's a part of the lease. It's within the lease payment anyway. So again, you're not breaking your bank if you're going to finance and lease for a Gap. All right, another question I got for you is this: there's a lot of people that move down from New York to Florida, including myself. Is it legal for my management to threaten foreclosure on me for sending HOA invoices to an incorrect address? I recently moved from a condo in Bradenton from New York. My HOA instructions and unique PIN for accessing the payment portal was sent to the wrong address for consecutive months, and I had asked 3 times for my management to send the paperwork to my new address. For this reason, I was unable to pay my dues at the scheduled times for these particular months.
So typically with HOAs and condo associations, and they can be very difficult to deal with. We've dealt with them many times. but they have a very strong power in the state of Florida. So typically, those are covenants that run with the land, which basically means when you bought that property, you were put on notice that you have to pay that money. So certainly it may be a defense or a partial defense that they sent it to the wrong address, but at the end of the day, you still owe the money. It's no different than, hey, you bought a house, you have a mortgage, you have to pay that mortgage every month. If they sent the address or the invoice to the wrong address, you're still on the hook for the money. Now, where it gets a little tricky is, HOAs can then start tacking on late fees. If they hire attorneys, they can tack on the attorney's fees, and it becomes very expensive very quickly. So, unless there's a very solid defense, my recommendation is usually to pay it as quick as possible, because what we see in these cases often happens is, and actually I had this case that went on for about 5 years one time where, it started out where the HOA was arguing that the guy owed like 20 grand or something. Once we actually looked at it, they were only owing about $50.
Wow.
And it was a late fee. The only difference was whether they owed this late fee or not. And so the HOA probably spent, I don't know, $30,000, $40,000 in attorney's fees arguing over $50. And so it came down to basically, well, if the HOA wins, yeah, they get their $50, but they could also get 30 or 40 grand.
Mm-hmm.
And then they can foreclose on your property to collect that. So they have a lot of power, a lot of enforcement power to make sure they get paid. And so on the client's perspective, he had attorney's fees too. And sure, there's the principle of it. You want to go to court and be right, but then, at the end of the day, he was looking at, well, is it worth the risk, right? Is it better just if you can get both sides to agree to walk away and each party owes nothing?
Right.
Or do you want to take the risk and, hey, maybe you get your attorney's fees back, but if you lose, maybe they get quite a bit of money and you're going to pay them one way or another. You're
Right.
going to lose your property or you're going to pay them. So, typically, while I've argued with HOAs and condo associations many times, and I know how frustrating it can be, under the statutes of the state of Florida, they have a lot of power. So you have to be very careful with how you deal with these situations when there are late fees, and they can absolutely foreclose on the property just like they're threatening to do. And, attorneys who deal with, who represent HOAs and condo associations know that they can get their fees paid, and they know they have a lot of power to get their fees paid. And in my experience dealing with them, they rack up a lot of fees. So you got to be very careful. Again, if you want to call the office and get some advice, I'm happy to talk to you about it. But, from what you're telling me, my recommendation would probably be to try to resolve it as quickly as possible before those fees increase.
Yeah, my experience with HOAs aren't the best. We put up a fence in the backyard and had to be a certain height. And because of the caps on the top of the fence, sometimes the fence have like the little arch caps.
Mm-hmm.
It was off by 4 inches. So I had to take those caps off, and we had to seal it up with some like liquid concrete to make sure no water goes in there. But they're quick to find things. They're not that quick to approve things, but they're quick to find things. All right, one more question for you. We're going to stay on sort of HOA. We're going to move to rent. This is a good one because I dealt with this personally myself. A rental property. I rented this apartment for 13 months. On the contract, it specified all the payments that the apartment complex needed up until the last payment they stated in April. Our rental contract was extended for 7 days because we weren't sure that we were going to be able to move into a new house in time, but then we were able to, and we told the apartment contract that we were able to do it. However, because we mentioned we needed the extension, they're still forcing us to pay for that 1 week. Are we still liable even though it isn't on paper or in a contract?
Well, if you stayed there for the 7 days, you owe them something for it. The question becomes, what do you owe them?
So this person moved out, I guess you could say. So
they moved out?
They
before
moved
the 7
out.
days?
They handed in the keys the week before they went into their property. They were out before those 7 days,
Gotcha.
And they're still saying they're liable for the payments.
But did they agree? They asked them to extend it for those 7 days, right?
Yeah.
And so, I think it would come down to what kind of notice provision was in the lease. I mean, basically, you did ask to extend through those 7 days, even though you turned your keys in early.
Mm-hmm.
So theoretically, they reserved that a property for you so nobody else could move into it. Not that it's ever that quick of a turnaround, but just looking from a legal perspective, they held that property open for you for 7 days. When they were advertising on the market, they pushed those, the next rental period back 7 days and
Right.
things like that. So, arguably you would be liable for it under that scenario. But anytime we're dealing with any sort of case that involves rent or leases, typically your rights and obligations are going to come down to what's in that lease agreement. So that's really what you have to look at.
All right, folks, we're going to have more DeWitt Law Review coming up next, right after the three big things you need to know here on WDBO 107.3 FM and AM 580, Orlando's News and Talk.
All right, the crash happened. I was at a stop. The car was coming in, rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I just kind of sat down for a couple minutes, gather my thoughts, after the ambulance and stuff. Got discharged, went home. I was really trying to think about what to do next because, that was my first accident. Of course, you hear all the time, call an attorney. So I wasn't really sure what route. I reached out to a friend of mine and she was just like, hey, I have someone you can reach out to. And she said, just call Mo.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Mo was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing. They're mailing out a letter, anything. I'm always in the know, so that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Mo.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's News and Talk. For legal advice, you can call the office anytime at 1-800-DeWitt-LAW or interact with our show by sending an email to ask@dewittlaw.com. That's ask@dewittlaw.com. My name is Casey Wright. I'm here with the host, Mr. Mo DeWitt. And Mo, we're going to continue questions here into the last segment for our show this morning. And the question is this: my ex is not on the deed of a home. If I add it, can she take a loan against the house? I bought the house while married with inheritance. She gets to stay in the house for 3 years, and then we sell it.
So we've dealt with this many times, and I've told the story about the person who got divorced, gave his wife half the house. Then they got back together. He added her name back to the deed and then gave her half the house again. So he ended up paying 75% of the house to her. Let's break it down basically. So if you have an inheritance is typically a non-marital asset. It's a separate asset. It's one of the exceptions to anything that's acquired during the marriage is split 50-50. So assuming that you took that inheritance and you purchased a home with it, and the home was solely in your name, and that you could show and trace that the inheritance purchased the home, at least the purchase price of the home would be protected as a non-marital asset. Now, there is what we call the CAW formula in the state of Florida, KAA, and that does state that any appreciation or increase in value could be considered a marital asset, and so you could have to pay out half of the increase in value over time. So there is that one exception. But assuming it's an inheritance, it would be his money, his property. However, if you add her name to the deed, then it is presumed that you are gifting her half of the home. So it's presumed basically you're waiving your right to that inheritance being non-marital. So yeah, if you add her name to it, she could take half of the house as part of any divorce. Now, you also asked, can she take a mortgage on the home? And so, assuming this is a homestead property, if it's homestead in the state of Florida, both parties have to sign off on the mortgage. And the whole purpose behind that is they don't want one spouse kind of taking out secret mortgages on the home, and then the other spouse ends up homeless without, their knowledge that this loan was there and it didn't get paid, and so on and so forth. So it's kind of a provision to protect from that scenario. If it's an investment property or something else, then that doesn't apply. That only applies on homestead. So theoretically, she should not be able to, if it's a homestead, she should not be able to take a loan out on the house without your signature and without you acknowledging the loan. Now, I've seen some mortgage companies miss that before, and it leads to a lot of litigation down the road. But that's the way it's supposed to be. However, like I said, if it's an investment property, if it's not a homestead property, if it's a vacation home, something along those lines, then in those scenarios, either party could go out and take a loan on the property. It doesn't have the same protections against it.
Now, from this question, would you say that these people are going through? Obviously, he says X, but is this advice more for people who have been divorced already or are going through a divorce?
Well, I'm kind of assuming, even though they say X, that they're not legally divorced.
Okay.
I don't, and maybe they are. Maybe, he's trying to do some sort of asset protection thing for his kids or something like that. We probably need to know a little more details on that. If that's the intent, if you're trying to do some sort of asset protection to maybe give the house to your kids if something were to happen to you, there's much better ways to do that than just adding her to the deed. You can do ladybird deeds where you could add your kids. You could set up trusts. There's all different ways that you could do that. That would be a much better idea than just adding her on the deed. Because once you add her on the deed, especially if you are divorced, if you are actually legally divorced, then you become co-tenants, where basically each party owns 50% of the home, whether you like it or not. Mm-hmm. It can lead to a lot of litigation. We've seen it lead to a lot of litigation before. So you want to be careful in what you're doing. And so whatever he's trying to do here, I recommend you talk to an attorney, because we have to really know what his goal is. There's some sort of goal here that we don't know that's not really disclosed in this email. And so in order to give proper advice here, and this is what I tell my clients all the time, really, is you have to kind of know what your goal and intent are in order to figure out how to navigate you there, right, to get you on the right road to get you to where you want to go. So depending on what he's trying to do, I think there's probably a better way to do it than just adding them to the deed. But yeah, what I was kind of referring to was if they were, even though he was saying X, I was kind of assuming they were still legally married. So that's kind of more general advice if you're still legally married.
Folks, if you want to get in touch with the DeWitt Law Firm, you can go on their website at DeWittLaw.com, DeWittLaw.com, or you can call 1-800-DeWitt-LAW. If you want to interact with our show, you can send us an email, ask us a question at ask@DeWittLaw.com. For Mo DeWitt, I'm Casey Wright saying so long. We'll see you again next week here on the DeWitt Law Review on WDBO 107.3 FM and AM.